Good morning, good afternoon, and welcome. I'm Ellie Kemeter with Foley and Lardner, and I'm pleased to welcome you to today's Employee Benefits Broadcast Web Conference. In this program, we address fiduciary duties for 401ks and defined contribution plans, more dangerous than ever. I'd like to take a moment to introduce our program speakers for today. First, we have Greg Duge. Greg is a partner with Foley and Lardner and the chair of our Employee Benefits and Executive Compensation practice. Since 1984, he has practiced in the employee benefits area, representing employers with respect to ERISA and tax issues that arise in connection with the pension, profit sharing, and welfare benefit plans that they sponsor. Second, we have Isaac Morris. Isaac is a senior counsel with Foley and Lardner, where he focuses his practice on employee benefits, executive compensation, and ERISA issues. Before I turn the presentation over to our speakers, I'd like to go over a few housekeeping items. Today's program will last approximately 1 hour, followed by a short question and answer session. We encourage you to submit written questions during the program. Please type your question into the Q&A widget open on the left-hand side of your screen. We will respond to written questions at the end of the program, time permitting. The webcast console you are looking at can be completely customized. You can resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. If you experience technical difficulties during the presentation, please visit the webcast help guide by clicking the help widget below the presentation window, which is designated with a question mark icon. The PowerPoint presentation will be available on our website at foley.com in the next few days, or you can get a copy of the slides in the resource list widget. As a reminder, today's program is being recorded and will also be available on Foley's website in the next few days. Foley has applied for HRCI credit and will apply for CLE credit after the web conference. If you did not supply your HRCI or CLE information upon registration, please send an email to Ellie Kemeter at ekemmeter@foley.com. To be eligible for CLE, you will need to log into the On24 session and answer a polling question during the program. As a final note, those seeking Kansas, New York, and New Jersey CLE credit are required to complete the attorney affirmation form in addition to the polling question that will appear during the program. A 4-digit code will be announced during the presentation. Please email the form to Ellie Kemeter at ekemmeter@foley.com immediately following the program. And now I would like to turn the presentation over to Isaac Morris.
Thanks, Ellie. So again, a very warm welcome to everyone joining us. And as Ellie mentioned, today we want to talk about how to control fiduciary risk with respect to 401k and other defined contribution plans. And we're really hoping that everyone finds this discussion instructive and useful. We've designed it not only for the benefit of those of you who may serve officially on the plan investment or compensation committee, but also for those of you who assist such individuals or really have to deal with your plan in any manner. We know from firsthand experience that those of you who serve in an official role on the committee often become busy with other responsibilities, and you have to delegate to others. And maybe you're one of the individuals that gets delegated to. Maybe you attend the meeting in a semi-official role, or maybe you don't attend these meetings at all. But regardless, how close you are connected with the plan or how removed you are, we're casting a wide net today. And that's because that we believe that once you start dealing with your 401k or your defined contribution plan to some extent, it's really just a matter of time before the subjects of fiduciary risks and responsibilities come up. So again, whether you're part of the frontline process or you're a little bit farther removed, we think you have something to gain from this discussion today. And we want to start the discussion by jumping right to the conclusion rather than building up to it. We don't want our presentation today to be viewed as a cliffhanger where you're reading until you can find that last chapter of what actually happens. We're not trying to hold the resolution back to the very end. We're going to put that theme right out on the table right at the outset, and then we're going to continue to repeat the conclusion throughout the presentation. And so really the theme that we're going off of today is how you can control the narrative, how you can control the story of fiduciary risk with respect to your plan. And along with that, we have a couple of sub-themes of having a deliberative process with respect to actions taken for your plan, and then making sure you document that process. And many of you may have noticed that there's been a significant increase in the volume of 401k or defined contribution litigation. And it seems to us here, at least, that in far too many cases, this is because plan fiduciaries have permitted others, such as the plaintiffs or the court, to control the narrative, meaning to control how the story is told. And so in many of these cases and situations that we're going to discuss today, you might ask yourself the question of which party controlled the narrative, which party had control over how the story was being told. And that's because that party usually wins. Did the plan fiduciaries control the narrative when they had the chance to? And if not, what happens when the plaintiff is permitted to fill in blanks in the story? And so again, we'll be coming back to and hitting that theme over and over again today. What's interesting about this is that we're not discussing a new theme, and it's certainly not limited to 401k plans or other defined contribution plans. In fact, this theme concerning which party controls the narrative plays out in a variety of employment-related contexts, and admittedly probably a host of other areas as well. A while back, we had an employment discrimination colleague of ours who raised a similar point. And he had been asked if he had one piece of advice to employers for avoiding employment discrimination claims, claims such as age discrimination, sex discrimination, and so forth. So what would his answer be? What would be the one thing employers could do better? And he responded only partially in jest, "Don't be lazy." And he went on to explain that when he handled a discrimination case that was problematic for the employer, it was normally because the employer hadn't documented the performance shortcomings of the employee. So that when the employee ultimately was terminated, it permitted the plaintiff, who's now alleging this prohibited discrimination, to seize control of the narrative. To seize control of the story that's being presented to the judge or the jury. And in essence, that's pretty much akin to a self-inflicted wound, right? Something that could have been prevented through diligence and effort and documentation of that effort, but just wasn't. And our submission to you today is that the same dynamic is at play here in the 401k universe. Again, there's been a significant increase in the amount of benefits-related litigation, including class action litigation. And many of the results that are unfavorable to plan sponsors and plan fiduciaries are too often self-inflicted. So with that, let's take a step back and explore how we got to this point where this defined contribution and 401k litigation has become such a significant concern. And that's where we'll start off with this first slide. So in the beginning, and I've always wanted to say that during a presentation, in the beginning, meaning back in 1976 when ERISA first became effective, the retirement universe primarily consisted of defined benefit plans. And as you know, in a defined benefit plan, the plan sponsor bears the risk of having insufficient plan assets. So if someone made a mistake, such as maybe a plan fiduciary entered into a bad contract, and that contract provided for an excessive fee that in turn reduced plan assets, well, that generally didn't affect the plan participants. Instead, it just meant that the plan sponsor had to pony up a bit more money. Plan sponsor is responsible for funding the plan, so they have to kick in a few or a lot of extra dollars. And so what we ended up with was ERISA fiduciary litigation was generally limited to egregious situations, such as when a plan fiduciary loaned substantially all of the plan's assets back to the plan sponsor, who then went bankrupt. Right, so we have these situations that were egregious, they're generally obvious, not a lot of teachable moments going on. Good. Slides are working. So things started to change back in the early 1990s. We have this sea change. And it starts out slowly, but it really starts to pick up steam in the first decade of the 21st century. And what happens is plan sponsors start shifting from defined benefit plans to defined contribution retirement designs, right? Such as the 401k plan that's so prevalent now. And this shifted the investment risk over to plan participants. Now, granted, it gave them the risk of both the upside and the downside. And it also provided plan sponsors with more predictable accounting treatment. And so the concept was that the employer's quote-unquote risk associated with the benefit accrued in any year for a defined contribution plan was pretty much limited to the employer making the specified contribution for that year and generally with no legal commitment to contribute in future years. And for the most part, this sea change has worked very, very well. But there has proven to be one exception, as there always is, right? And that exception involves the fiduciary duty or fiduciary responsibility rules under ERISA. Now, these are rules that didn't change, and we're going to be talking about these rules shortly. But the rules that are there today are the same rules that were in effect when ERISA first became effective in 1976, about 39 years ago. What did change, however, was we had the change from the defined benefit environment to defined contribution plans, and that changed the incentives. And so in the defined benefit environment, there's oftentimes little incentive for a participant to fight. The participant is entitled to this fixed benefit that's determined under the plan's formula. And so really, as long as the plan remains solvent and as long as the plan sponsor is financially able to support the plan through contributions, the participant's going to receive the promised benefit. And if something was done incorrectly along the way, well, it might ultimately cost the plan sponsor some additional money, since the sponsor is the one who supports the plan, but there is less litigation. And for any of you out there who might be participants in a defined benefit plan, or if I was a participant in a defined benefit plan, the thing that I would care most about is, am I going to get my promised benefit, right? And if I'm receiving that benefit, well, as long as that benefit continues to come every month, I'm generally not going to make any waves. But you have the situation being reversed in the defined contribution universe. In that situation, everything that goes through the plan, so whether it's the investment return realized by the plan's investments or the expenses and fees that are charged against the plan and accordingly against the plan participants, well, all of that impacts the participant's ultimate benefit, since the benefit is whatever that account grows to be or arguably could grow to be. So this gets us to our current state, where we have a magnified volume of ERISA litigation as opposed to the historical norms. And we have much of that litigation being class action litigation. And in fact, there are now plaintiff-side law firms that concentrate heavily in ERISA class action cases. And there have been more than a few large judgments and settlements, and we'll talk about a few of those today. But before we get into that, let's spend just a minute going over some legal background and talking about ERISA's fiduciary duty rules, and in particular the prudence rule. And when we're talking about prudence, we're really talking about being sensible, having good judgment for the situation and circumstances, that kind of a concept. And if you look at the slide here, you'll see that these rules are very general in character. They set forth some general standards of conduct, but they're not detailed rules covering prescribed situations. And the prudent rule, which is the one that's at issue in many cases, sets forth a prudent expert standard. And as the slide says, it requires that a fiduciary discharge his or her duties with the care, skill, prudence, and diligence under the circumstances that a prudent person familiar with such matters would use. Now, importantly for our purposes, the prudent standard is not supposed to be an after-the-fact evaluation of whether the fiduciary's decision was correct or incorrect. Instead, that prudence requirement is intended to take into account the decision-making process that's followed by the fiduciary. And this is what can get some people into trouble. Mind you, it does not require you to have a crystal ball, to have to look into the future and guarantee the best outcome. But it does require you to have a sound process and to document that process. So again, there's that theme that's going to continue to come up today. And it's also worth noting at this point, I think, another point that we'll come back to, and that is even in some situations where you decide to take no action, that's still something you want to document and note the reasons for. So if you look at a situation and you decide, no, we want to keep the status quo, we've done our diligence here. Here are the reasons we want to keep the situation as is. That's a deliberative process, but you want to make sure that you're documenting that process. So we have a nice little quote here on this slide from the Department of Labor regulations that focuses not on the end result, but on the process. Has the fiduciary given appropriate consideration to the relevant facts and circumstances? And this concept is often referred to as procedural prudence. So now let's move from those general fiduciary rules and start getting into application in some of these 401k cases. And in the 401k arena, the class action litigation that we see, or that's out there, generally involves one or both of the following arguments. First, that there was an imprudent selection of plan investment options or a monitoring of those options. And second, that there's been excessive fee arrangements or a failure to monitor fees or some other challenge that's going on to the amount of fees, and whether it's direct or indirect, the fees that are ultimately being borne by plan participants. And I do want to take a moment here to note that plaintiffs don't always win, especially if you look at past history. They don't have that strong of a track record. And the slide here cites to a couple of cases, in fact, in which the defendants prevailed. And I want to take just a moment and talk about the Hecker v. Deere case. It's an interesting case. It comes out of the Seventh Circuit, so it's controlling law for Wisconsin, Illinois, and Indiana. Excuse me. And briefly stated, what happened in that case is the plan at issue there had about 30 investment options, so quite a few. And they were of all sorts of shapes and sizes with various levels of management fees. And the plaintiffs in the Deere case argued that many of the mutual funds had high fees, and that the plan fiduciary should not have selected them for use in the plan. Okay, so it goes back to saying, hey, there's some excessive fees going on. We're going to sue on that ground. And if you look at the decision by the appellate court, by the Seventh Circuit, we think it's very fair to say that the court in this case was quite dismissive of the plaintiff's claims. It looked at everything that was going on. It saw a variety of well-recognized mutual fund names. It didn't see anything to indicate that these well-recognized names weren't prudent investments, even if they weren't the lowest cost choices that could have been made. And so what you end up with here is this is a case in which the plaintiffs not only lost, but they lost big. Well, within the past year, we've seen some changes going on, and essentially some reversal of fortunes with plaintiffs making some big headway. There were some large verdicts in decided cases. The ABB case that we're going to be talking about shortly ultimately cost the company $13.4 million, so quite a lot of money, and as well as corresponding legal fees and internal administrative costs that were incurred. And then there have been some large settlements prior to trial. The Nationwide Insurance matter. Maybe you've seen that in the news, where there's a proposed $140 million excessive settlement fee. And that lawsuit has been going on for a long time. It was originally filed back in 2001, and it was over an allegation that undisclosed revenue-sharing payments from non-proprietary mutual funds were made in violation of ERISA. And we bring that up, we mentioned that background to highlight the fact that the company has been incurring legal fees and internal administrative costs to some extent for about 14 years. And also, importantly, there are additional cases that are getting to trial. There's an excessive fee case going on against Boeing, and we'll be discussing that later on as well. And it's one of the latest examples of something getting to trial. So, you probably know this, but defendants normally fight really hard prior to trial. And historically, they've been successful in getting many cases dismissed at the pretrial stage. But if a defendant can't get that done, if defendants can't get this done, then they often will end up settling prior to trial. And that's because for a number of reasons. Trials themselves are very costly, they're time-consuming, they're distracting. That's not why you got into business. You can have bad publicity. There are all sorts of unknowns. You're never quite sure what a judge or a jury is going to do. So again, if a defendant can't get something dismissed pre-trial, it will often result in a settlement. So let's get into the details of some of these decisions, and so you can see what's actually going on. So let's start out by talking about this Tussey v. ABB case. And this case caused quite a stir when it was decided a couple of years ago, back in 2012. And it caused a big stir in large part because it was a plaintiff win at a time when defendants were really otherwise having a lot of good success. And so this decision then worked its way through the appeals process just a year ago, back in 2014. And to give some brief overview on what happened, back in 2012, the district court issued its decision. And at that time, it awarded a total of $34.3 million to plaintiffs. That's not including a $13.8 million award for attorney's fees. And with respect to the $34.3 million, there were two parts. It was broken down. First, there was $13.4 million for the failure to monitor and control record-keeping fees. The plan at case in the ABB decision had a fee system where the record keeper got paid based on a percentage of assets. So, for example, 10 basis points. So what happens there is the record keeper got a raise as the plan assets increased in value. And the second part of the decision was a $21.8 million award that was granted in connection with a change in investment options. The plan had replaced the Vanguard fund with a new Fidelity fund, and that Fidelity fund didn't perform as well as the outgoing Vanguard fund. And what's relevant from the district court opinion, the trial court opinion, is that it focused on concepts of procedural prudence. It said that, it found a lack of a deliberative process and documentation of that process for reviewing the trustee record-keeping arrangement. So in other words, there wasn't any documentation of a process to review and evaluate and monitor the contracts and performance of the vendors. And once again, as I said we would, we're hitting on our themes of a deliberative process and documenting that process. So then the decision works its way through the appeals process. And the Court of Appeals then reverses part of the judgment. It reversed the $21.8 million award that related to the change in investment options, the second part of the award. And the court said, and quite correctly we think, that the trial court fell victim to looking at the substantive results. The Vanguard fund that was replaced had performed better than the Fidelity fund that had been inserted. And the trial court just got caught looking at the substantive results rather than looking at that decision-making process. So at least here, the appeals court recognized that the prudence standard isn't a crystal ball standard. So this is good news for the defendants because this part of the award was reversed. But the court also refused to reverse the $13.4 million award that related to the allegedly excessive record-keeping fees. And, of course, the defendants weren't relieved of their own legal fees and other administrative costs associated with defending the lawsuit. So what does all this mean? Why did I just spend all this time discussing this one case? Well, stated most simply, the lack of a process or the lack of documentation that the fiduciaries monitored the situation basically carried a $13.4 million cost with it, plus any transaction costs such as attorney's fees and any internal administrative costs that the company incurred. And if you look at that appellate decision, you'll see that the court didn't say that the particular fee arrangement was inherently inappropriate, although we should note that those fee arrangements are going out of style. But what the court did focus on and said was that, look, when a plan sponsor chooses a particular fee arrangement, it must have gone through a deliberative process for determining why such a choice is in the plan's and participants' best interest. And the takeaway here really is that, look, if you don't record or document the review process, the court is likely to say that it didn't happen. So again, hitting on those themes of that deliberative process and documentation of that process. And at this point, I'm going to turn things over to Greg Douge to continue the discussion. Greg?
Thank you, Isaac. Let's take a moment as we transition here just to summarize where we've been thus far in the presentation. Isaac explored the dramatic increase in ERISA fiduciary challenges and walked us through the ABB case, in which even though the plan fiduciaries had a partial victory at the appeal level, they still are on the hook for $13+ million. And beyond the nuts and bolts of the case, there's another very relevant point about the ABA case. Isaac described the 2004 developments, but it's worth noting that this is a lawsuit that was filed back in 2006. So this particular dispute has occupied more than 8 years. And that's significant. Isaac touched on this before, but it's significant because in many cases, an employer or plan fiduciaries don't think that they've done anything wrong, but they choose not to fight. In ABB, the employer chose to fight and has been doing so for 8 years. But in many cases, the employer will choose not to fight if they cannot resolve the case at the early stages. They might not want to fight because the fight itself is expensive, attorney's fees and court costs, as Isaac mentioned. They might not want to fight because the fight is distracting, employers of the plan sponsor spending time and effort on the litigation rather than on the ongoing business. They might not want to fight because they don't want the negative publicity that comes with the fight. Even if the employer or plan fiduciaries win in the end, the allegations create bad publicity for an extended period of time. And so there is an interesting dynamic that often plays out in these cases, just as Isaac mentioned. That is, the employer or plan fiduciaries try very hard to get the lawsuit dismissed at the early stages prior to trial. If this can be accomplished, the lawsuit might be disposed of without large expense and without an extreme amount of publicity. But if an employer or plan fiduciary is unsuccessful in getting the case dismissed early in the process, many plan sponsors simply choose not to fight. Instead, they settle the case for business reasons. And the Kraft decision, which is referenced on the slide, might be an example of that. The Kraft case involved a claim of imprudent operation of an employer stock fund. The district, or lower or trial court, granted summary judgment to Kraft. That's what we mean by getting the case dismissed at the pretrial stage. Kraft essentially said to the judge, a full trial isn't necessary because they can't win. They don't really have a claim. And the court agreed. But when the plaintiffs simply meaning the people bringing the lawsuit, when they appealed, the appeals court said, not so fast, and they sent the case back to the district court for trial. Well, consistent with the themes that we just articulated and that Isaac touched on earlier, there never was a trial. Kraft settled the case for $9.5 million. We don't need to get into the details of how the employer stock fund worked, but let's just say, for the purposes of our discussion, that there are two basic methods for operating an employer stock fund. The Kraft fiduciaries had explored whether to change from method 1, the method they had historically been using, to method number 2. However, according to the Court of Appeals, the record did not reveal that the fiduciaries ever made a decision. So method 1 simply continued. And the appeals court viewed the failure to make a decision as a possible fiduciary breach, requiring it to send the case back to the lower or trial court for a full-blown trial of the issue. And as we talked, at that point, Kraft settled rather than going through the trial. The court wrote that the failure to make a reasoned decision as to the preferred course of action under circumstances in which a prudent fiduciary would have done so is a breach. Now here's what I want to ask. Do we really believe that the plan fiduciary simply failed to make a decision between option 1 or option 2, method 1 or method 2, after having considered the issue? Do we really believe that? It's possible, I suppose, but frankly, I kind of doubt it. I think that the more likely explanation is that a decision was made to continue with the method that had always been used, but that decision was never documented. And if that's the case, if I'm correct about that, then the Kraft case might simply be a case in which the failure to document cost $9.5 million. There was nothing inherently wrong with the manner in which the employer stock fund was operated. Method number 1 that Kraft used is a perfectly permissible method for operating an employer stock fund. It's simply an alternative, but it's perfectly appropriate. There are plenty of good reasons why an employer, in designing its plan, may choose method number 1. However, Kraft considered whether to move to method number 2, and the court took them to task for failing to reach a decision. So might this simply be a case about what happens if plan fiduciaries, or those who support them, get lazy? This goes right back to the point that Isaac made at the outset of the conversation when he was referencing by analogy the employment discrimination lawyer and what happens when you don't document employee performance shortcomings. In this case, there is a high probability. Obviously, we are not familiar with all of the details of the Kraft decision, but in this case, there is a legitimate possibility that this is a $9.5 million penalty for failure to document. Now, Kraft actually took place a couple of years ago, but the same dynamic is playing out in current cases as well. Let's take a look at the new Boeing case that Isaac mentioned earlier. This is an excessive fee case, allegations being made that the investment options carried excessive fees, that the record-keeping fees were excessive, etc. Now, I need to say at the outset that Boeing hasn't lost yet. The December 30th, 2014 decision, so there was a decision right in the waning days of 2014. That decision was at the pretrial stage, consistent with our themes, Boeing trying to get the case dismissed prior to trial. And as we discussed, Boeing has a huge interest in trying to get that done. But the court disagreed and ordered the case to proceed to trial. So we don't know who's really going to win at trial. But the important point for us is to take note of how things have changed over a 5 or 6 year period. And we want to do that by comparing that John Deere case that Isaac talked about to this Boeing case. Isaac described that Hecker versus John Deere case, which was the 2009 case in which the court easily rejected an excessive fee claim And as Isaac noted, the court was downright dismissive of the plaintiff's claim. Not only did the plaintiffs lose, they lost big. The court really gave their arguments very short shrift. But here we are at the end of 2014 and early 2015 with an excessive fee case that, unless Boeing decides to settle, is going to trial. And I think this illustrates a cyclical nature to this. There is a round of cases in which employers and plan fiduciaries win, but the plaintiffs always regroup, and the plaintiffs refine their theories, and eventually the plaintiffs have some success. The quotation on this slide, I think, nicely summarizes the ebb and flow in these fiduciary cases. I saw this on a blog post from Thomas Clark, and Mr. Clark states that having been in the trenches in 2009 after the John Deere decision, betting $1 that a decision such as this, the Boeing decision, would be likely someday would have been the waste of a perfectly good dollar. In other words, back in 2009, after the John Deere case was decided, it was almost impossible to imagine how a plaintiff was going to get an excessive fee case to trial. And yet, 5 or 6 years later, that's exactly where we are. It's this ebb and flow where even if defendants win to begin with, plaintiffs refine their theories, they come back, and they ultimately get some traction. And so 5 or 6 years later, 5 or 6 years after the John Deere decision, the world looks like a vastly different place. That's a very short period of time, but the world has changed. The ERISA world has changed in just that short period. So what influenced the court in deciding that this excessive fee case needed to go to trial? And the court made a couple of comments. First, the court noted that there was no evidence that Boeing solicited competitive bids for the plan's record-keeping services. Now, I want to caution there that we don't necessarily believe that competitive bids are an absolute requirement. But what is imperative is that plan fiduciaries have fee analysis or benchmarking studies to indicate that the fiduciary studied the issue and that the fees are reasonable. Competitive bids are one way to do that. Fee benchmarking is another way to do that, but fiduciaries need to do something along those lines to demonstrate that they have studied the reasonableness of fees and whether the fees that the plan is paying are within the market norms. That's the first point that the court made. Second, the court noted that Boeing failed to cite any evidence of procedural prudence in support of its selection and monitoring of plan investment options and their fees. There's that term, procedural prudence. There it is again. Is there a paper trail showing a good faith investigation, a good faith and deliberative process? Is it a thoughtful process, even if someone might disagree with the end result? We see this theme time and time again. And by the way, although not in the PowerPoint materials, within the last month, Lockheed Martin agreed to pay $62 million to settle an excessive fee lawsuit. So Boeing and now Lockheed Martin indicate that this isn't a tale about ancient history. This is relevant stuff today. It's not just cases from a few years ago. This is going on in all kinds of cases that are pending before the courts today or being settled today. So let's step back. We've now looked at 3 cases, ABB, Kraft, and Boeing. And let's talk about lessons learned. And the lesson, it seems to us, is apparent from the common theme. Whether it's the ABB decision, the Kraft decision, or the Boeing decision, in each case, the court focused on procedural prudence. What was the decision-making process? Was a decision reached, and was it documented? As Isaac stated right at the outset, procedural prudence is as important and maybe more important today than it ever was. And it is particularly important if the employer has hope for getting a challenge dismissed at the pretrial stage, where so much is based on the written record. As discussed, litigation is tremendously expensive, and if the employer has a hope for an early dismissal of a challenge, there must be a written record that supports the decision that the employer made. On this slide, we offer another way to think about procedural prudence. When a plaintiff or a plaintiff's lawyer builds a case, they're telling a story, and the story has a theme. And the plaintiff's theme normally is that the fiduciaries didn't pay attention, or the fiduciaries had a conflict of interest, or the fiduciaries' conduct was so unreasonable that no sane, or at least prudent, person could have sat back and made that decision, or paid that fee, or continued with that investment option without further research and study. It just couldn't have been done without really getting more help, more assistance, more study. And had the fiduciary undertaken that additional effort, they would never have done that. And that these themes seem to be at the core of the plaintiff's arguments in all of the cases that we discussed. If you think back to, and I know we didn't get into the real details of the case, but if you think back to the story in ABB, that the plan fiduciaries continued to pay excessive fees and they didn't pay attention as the fees got bigger year after year after year as the assets increased and the fee, which was based on a percentage of the assets, then went up correspondingly. So the plaintiff's argument in ABB is that the plan fiduciaries basically didn't pay attention. They didn't monitor. They didn't keep, even if the arrangement was acceptable at the start, it became unacceptable and unreasonable over time, and the fiduciaries didn't pay attention. That's the story in Kraft. Now, the court filled in some of the blanks there rather than the plaintiff's attorneys, but the argument that the court filled in the blanks for was that the plan fiduciaries didn't follow through. They dropped the ball. They didn't pay attention. They talked about something, and they didn't actually make a decision. Again, I question whether they really didn't make a decision, but that was the conclusion that the court made. And so it's all consistent with this theme that somebody didn't pay attention, somebody didn't follow through, somebody didn't have a thoughtful, deliberative process, and they certainly didn't document the process so that a court could see it early on in the proceedings. So what should plan fiduciaries do? And it seems to us that plan fiduciaries should take charge of the narrative by documenting what is being done and the reason for it. This is particularly true for actions that preserve the status quo. But as a starting point, our premise is that plan fiduciaries have the ability to control the narrative, and that plan fiduciaries oftentimes get themselves in trouble when they don't do so, and then they allow a challenger to tell the story and control the narrative. Now, I want to go back to this point about why we think it's so important to document decisions that result in no change. It seems to us that one of the easiest cases for a plaintiff is when there is fiduciary inactivity. It permits the plaintiff to present in a sleep at the switch narrative, a lack of attention narrative, or some similar narrative. But the plan fiduciaries, again, have the ability to counteract much of this by documenting what is done and the reason for it. But we think that those are the easiest cases for a plaintiff, and we think the proof of that is look at the three cases we just talked about. Isn't that the essential narrative that the plaintiffs were painting in all of those cases? Our experience is that most fiduciaries or fiduciary committees are really very good at documenting why a particular investment option was chosen initially, or why a particular vendor was selected initially, or why a particular fee arrangement was reasonable when it was first put in place. But as you can tell from the cases that we just worked through, many of the attacks don't relate to the initial selection, but rather relate to why the investment was retained, why the fee arrangement was not revisited in light of changing circumstances, and so on. So in situations in which the status quo is maintained, think about documenting why. It's becoming more and more important to document why changes are not made. There can be good reasons for not making changes, but they need to be documented. Now, of course, on a substantive level, if the results are disastrous enough, if the substantive results are disastrous enough, a court can always find a prudence violation, even if there was a process. But in many cases, the fiduciaries don't have to have been perfectly correct. Rather, they only needed to proceed in an orderly fashion to evaluate the options, to make a decision, and to document it. And if the fiduciaries do that, then they will stand in good stead. But if they don't do that, and in particular where the status quo is allowed to continue, that's where a lot of these challenges arise.
Okay, so at this time, I'm going to read the CLE code for this program. So if you are in need of CLE credit today, please enter this 4-digit code into the poll question on the screen after it's announced and press the Submit button. So the code is XVS2. Again, that's the letter X, the letter V as in Victor, the letter S as in Sam, and the number 2. Again, if you are seeking CLE credit for this session, please complete the polling question by entering the code that was just announced. And the polling question will remain open briefly. Additionally, for those seeking Kansas, New York, and New Jersey CLE credit, in addition to the polling question, you will need to complete the attorney affirmation form and return it immediately following the program. A copy of the form can be found in the resource list widget on your screen. So at this time, the poll is now closed, and I'd like to return the program to our speakers.
Okay. So finally today, we would like to discuss the quarterly investment report in terms of our theme of documentation and deliberative process. We think that this may be a growing area of law, or may be an area of law that we'll see in the future, I should say. And we think it's important that plan fiduciaries not let the quarterly investment report become the plaintiff's best friend. Let's spend a few minutes talking about that, because I think this is a potentially interesting topic. We haven't yet seen cases in which the quarterly investment report is used by a challenger in its attack on plan fiduciaries, but we wonder whether this is coming. Remember, we talked before about the ebb and flow, about that whenever plan fiduciaries have success, the plaintiffs are nimble enough to refine their theories. And so we wonder if this might be the next area that plaintiffs look to. Many employers have hired a consultant to help with investment matters. The report is prepared by the consultant, and it's oftentimes, it can be 100 or 200 pages long. These things they're extensive. There's a lot of detail in it. A lot of it's frankly boilerplate, but a lot of material. So the presence of the consultant and the quarterly report is intended to provide evidence of a deliberative review and evaluation process. It's actually intended to help and protect the plan fiduciaries, to show the review and study that's going on every quarter with respect to the plan's investments. So why are we concerned about how something that was initially established to help and protect the plan fiduciaries might become a challenger's weapon, a sword instead of a shield? We raise the possibility because not all of the information in a report, if it's 100 or 200 pages, will be positive. For example, the report might show certain investments that have trailing investment performance. And the report might include suggestions that the consultant makes to all of its clients. What if the plan fiduciaries don't adopt the consultant's recommendations, or don't make a decision, as in Kraft? So there's a suggestion in the investment report, and there's no evidence that the plan fiduciaries even considered it. In those circumstances, might the quarterly investment report end up being a negative for the plan fiduciaries rather than a positive? Might the quarterly investment report allow a plaintiff to argue, similar to the cases that we looked at, that the plan fiduciaries didn't pay attention, they didn't follow through, they were asleep at the switch, the consultant had made recommendations, and there's no evidence in the record to indicate that the recommendations were acted on or accepted or rejected or even discussed. So we wonder whether that's a possibility, and that's why we wanted to talk about that today. So let's illustrate that with an example or two. Let's say that an investment option has trailing 1, 3, and 5-year comparisons relative to its benchmark. You know, that is, in these quarterly investment reports, there's usually a comparison of the performance of the plan's investment option against an index or against some kind of comparison group. And so let's say that an investment option actually has trailed over a 1, 3, and 5-year basis, but it looks pretty good in comparison on a 7-year basis. Now, what if the plaintiff's argument in this case might be, why hasn't the option been replaced if it has 5 years of performance trailing its benchmark? Doesn't necessarily mean the investment option has lost money, but it hasn't done as well as its benchmark or its comparison group. And we think about that, those possible arguments, because of the decisions such as the ABB decision. Recall that even though the appellate court overturned the aspect of the ABB decision that dealt with replacing the Vanguard fund with the Fidelity fund, the simple fact that the district court went down that road suggests to us that courts might have an appetite for this type of claim. So the question is when you have a fund that has this where it's trailed over the recent past, how do you document that so that how do you document the fact that the committee decided not to make a change? Well, here I think is the key point, is that there are multiple reasons why retaining the investment option might be perfectly appropriate. Obviously, every case depends on its own facts and circumstances. But here's just a list of possible reasons that would allow a fiduciary to take control of the narrative and be able to explain why, even though the quarterly investment report shows usually red ink, meaning underperformance, that the plan fiduciaries made a deliberative and reasoned decision to continue with that investment option. Possibility number one. If this is a stock fund, perhaps the manager was hired because the manager has a conservative bias, so that it's expected that the manager will underperform during strong market periods, but will actually outperform its competition during bad times. Now, if we think about the age that we live in, there haven't been any bad times during the last 5 years. So to get a full market cycle that includes both bad and good times, you have to look at the 7-year data that includes the bad market of 2008 as well. And so in this case, now assuming, if this is a true statement about the manager's bias, you might very well expect a manager who has a conservative bias to have made money, but to have made less of it than a more aggressive manager over the last 1, 3, or 5 years. But you would expect that manager with a conservative bias to have actually outperformed over a 7-year basis, because it probably still lost money in 2008, but it lost less money than its competition. If that is an accurate description of your particular manager, then document it, and you've explained away the red ink in the investment report. Similarly, similar theme, if this were a fixed income manager, does the manager invest in higher quality issues and thus take less risk than the comparison benchmark? For periods during which the market rewards risk, a conservative fixed income fund will underperform. But the manager might have been doing exactly what you hired the manager to do. Document it. This slide contains more examples. The first one of which relates to what I call a go-anywhere fund, simply meaning a fund that doesn't fit nicely into any particular style or market universe, and therefore it's hard to find a comparison group to it. And so the investment report will still have a comparison, but you might simply document the fact that the committee likes the fund, but that there isn't a very firm or meaningful comparison for that fund. Again, if if the plaintiffs can always argue that the plan fiduciaries made the wrong decision, but the test isn't whether the plan fiduciaries made the wrong decision. The test is whether the plan fiduciaries engaged in a procedurally prudent process. If you document that process, you should be okay. Last example about controlling the narrative. Record-keeping fees. The question oftentimes comes up, do we have to do a full-blown RFP if we are happy with our current record keeper? And I certainly don't want to discourage anybody from doing a full-blown RFP or from getting competitive bids, because you see things like the Boeing case where the court made reference to that. But if you don't do that, the question might be, what prevents a plaintiff from claiming that we paid excessive fees? And the plaintiff's argument is often that you have to take the lowest cost provider. And our answer, again, is control the narrative. Fiduciaries always have a need to avoid payment of excessive non-market fees. But ERISA doesn't require that the lowest cost provider be selected. So create your own narrative about what is important. Cost certainly is important, but also service level. If there is documentation that the cost is within the market range and the documentation that the vendor provides good service or provides the desired level of service, can a plaintiff really win? Can a plaintiff successfully argue that you need to take the lower fee when the record indicates that the fiduciaries determined that the fee to be within market and with the desired service level? You know, the gist of these examples is all part of this theme about controlling the narrative. And there's usually multiple reasons that might support a particular fiduciary decision. If the fiduciaries articulate one and document it, they're going to be in good stead. The problems arise when the plan runs on autopilot and plaintiffs are permitted to construct the narrative after the fact. That's why Isaac and I keep focusing on controlling the narrative and documenting it, and that's the procedural prudence that we see all of these court cases looking for. That concludes the substantive discussion for today. We hope that this served as a worthwhile exercise as you think about fiduciary compliance and how to document it for your plan and your program. And with that, I'll turn the program back to Ellie for a few closing comments.
Okay, thanks, Greg. If you did submit written questions during the program, we'll make sure to reach out to you separately to address those questions. So we invite you to contact any of today's speakers if you have additional questions or would like more information on their particular topics. And then this wraps up the web conference for today. And just as a reminder, today's program is being recorded and will be available on Foley's website in the next few days. And if you have any questions regarding our HRCI credit or CLE credit for this program, please contact Ellie Kemeter at ekemmeter@foley.com. And at the conclusion of this program, a questionnaire will appear. So please take a minute or two to give us your feedback about the presentation today. It's important to us to know your thoughts and helps us shape our programs going forward. Thank you for your participation.